WPS 594025 इसमें लॉर्डशिप जो हम जिसके यहाँ पे नहीं वो इंटरवेनर रिस्पोंडेंट है वाइफ नॉमिनी है लेकिन वो जो वाइफ को पूरा पेमेंट दिए जा रहे हैं हम नॉमिनी भी करते हैं
आप नॉमिनी आप कौन हो?
हम मदर
वाइफ इज नॉट एंटाइटल्ड टू पेमेंट
वाइफ को सारा पेमेंट करते जा रहे हैं सीनियर सिटीजन पे आई
ठीक आएगा कैसे केस लिस्ट में नहीं टाइड अप मैटर
नहीं टाइड अप मैटर कोड नंबर 14 का मैटर है
अभी मेरे को ये लिस्ट नहीं
लॉर्डशिप इस पे पूरा पेमेंट हो जाएगा
Sir, from the list member.
which list
Report number 14 matter. It was mentioned on Wednesday. It is a DSC matter where the last date of examination is on 28th.
तो हो गया आपका तो अदर साइड आया ना अलग-अलग काउंसिल अलग-अलग
नहीं वो इनका केस था मेरा
एक और केस मेंशन है उसमें अदर साइड में है
ये वेंसडे को मेंशन आना
दो बार मेंशन हो चुका है
वेंसडे को मेंशन किया था they have mentioned it the matter but my matter is a different matter.
That we have informed the council for the other side, both the council for the other side. The only pen date it must be heard together. Let's say 20th is the last date has been extended from 14th to 20th. Whether it may be taken up today or at least maybe tomorrow. Let's say all the matters are same.
Convenient to your lordship.
Convenient to this honorable court. All the matters are arising out of the same application.
extension of time
Age relaxation.
age relaxation is a matter of right for you.
No, not a matter of right, but there were 2015 the examination was not conducted, it was advertised. I made an application, cancelled, 2022 again advertised, cancelled, 2025 I am here,
Now you are
I have filled the form, my lords, they have not conducted. It is the failure of the state itself to conduct the examination.
There are judgments to that effect, ladies, when the earlier examinations have been cancelled, in the subsequent advertisement, the relaxation is made. Ladyship.
judgments कहाँ हैं?
All the judgments are in the IAO itself. I have annexed to the IAO. However, my matters are not on the board today. I was only paying it to be notified in this matter. I informed counsel for the both sides.
आप मुझे ये बताइए ना एक तो रिलैक्सेशन लेंगे तो पूरा एग्जामिनेशन प्रोसेस विल बी affected.
It is only with respect to the petitioner, not with respect to the other candidates.
No, I appreciate that, but the point is that the entire examination process will be stalled.
No, it will not. As a preliminary measure, my lords, they may be allowed subject to the.
Who will be allowed? It's a PIL.
No.
Only the petitioner.
Only the petitioner.
Only the petitioner. Why only the petitioner?
No, because they have come.
So
Because they have come before the court. Otherwise, the other people are not agree with that, my lords. When they are not interested to come and appear in the examination.
They are not.
Therefore, my lords.
And in fact, in the other judgment leadership, the honorable court has directed the JSSC to issue necessary corrections so that everyone can be accommodated. Both kinds of order may be passed subject to the fact that if we are able to convince this honorable court.
they have filed their counter.
No.
It's
on fresh file.
Fresh file. IA has been filed.
When was the advertisement made?
Made in June.
When did you file it?
June.
And we are filed.
And then what were the dates?
We have mentioned the matter.
In fact,
Only last week you have mentioned. Last
It
week
was
before
cured,
pressure
defects were
किया
cured,
गया।
pressure नहीं दे रहा है।
Pressure ही है ये last payment में। You see, just one day before the cut-off date, on that day I allowed you mentioning आप other side को जो contesting party है उसको
that was absolutely my mistake. I put on the last occasion JSSC was objecting, therefore I have informed JSSC. Now they are saying the state has to do the necessary things.
How many such petitions are there?
2 writ petitions with me, only 4 petitioners are there in these 2 writ.
And about it? Only petitioner in one petition.
Yes, I have only one writ.
Anybody else? No.
But today's matter also will go tomorrow. But
Lady for this be to the first appeal also.
Tomorrow in the supplementary cause list of this board.
Yes, yes.
Otherwise क्या होगा कि वो
वो
फिर
mention करना पड़ेगा.
What is it?
हाँ.
Yeah.
14 का है, 14 is not available.
Yes.
The supplementary cause list of this board.
Yes.
Such that they are put to notice in advance.
Yes, I have done that. Yes, I have informed written.
लिखिए
वो
जरा,
लिख दिया.
लिखिए जरा. These repetitions have been mentioned, which fall in the board of code number 14. Considering the code number 14 is not available tomorrow also. Considering the urgency of the matter, these matters are needed to be listed in the supplementary causes of this year.
From the lordship item performance, they will not just lordship mention the defect. All the
Which
defects.
causes?
They will this code lordship.
Why do you need to mention?
So lordship does not point out the limitation, how it is limitation in this case. I have all defects removed.
कौन सा?
Item number 3 lordship.
3 आइटम तक आप एंट्री कर सकते हैं.
सॉल्व हो जाता है.
आपको कहीं जाना है क्या?
Lordship 6 number.
कोई बात नहीं. इस तरह से मेंशन करने एंट्री करते हैं. लिस्ट से क्या एंट्री? सारा केस टेकअप होने वाला है. Why do you need to mention from my book? All the cases will be taken.
Yes.
From the list of code number 14, we have mentioned the matter is in fresh filing, it's a transfer matter.
Yesterday somebody had mentioned transfer matter. I have allowed. So same matter you are mentioning now.
It is listed in before the code number 14 in the supplementary list fresh filing. Requesting your ladies to be taken.
Serial number.
Serial number 2 in the supplement.
Same order कर दीजिए. मैं supplementary code of this code tomorrow.
Copy it.
Out of this matter, the matter relates to code number 14 and I am withdrawing this continuous matter.
So we go.
मेरे
Same
को
order.
इसमें मेरा सारा डिस्पर्स हो जाएगा डॉक्टर, इसीलिए हम
कोई बात नहीं.
हमें पास बचेगा कुछ नहीं डॉक्टर.
कोई बात नहीं.
सीनियर सिटीजन है डॉक्टर. डॉक्टर जी हम इन्फॉर्म कर चुके हैं.
आपको मेंशन रिजेक्ट कर दिए ना, फिर भी बोलना जरूरी है.
नहीं लॉटरी में ऐसा ये नहीं, लॉटरी को डायरेक्ट देने का हुआ था लॉटरी में, तो ये क्या ले लेना है.
Person, the date of birth is issued and the person has been issued retired on the basis of the wrong date of birth and hence the logic.
So there is no urgency.
The person has been retired and yet the date of birth, the exact date of birth has not reached the birth.
Same order.
Some particularly aware of the procedures of the code and not been deciding the process. There's one matter lordship has been pleased to reserve on 28th.
28.
28th.
28 date.
28th.
3
Because
months is late.
Why do you need to mention?
lordship, the department throughout has been that it's not gainfully employed.
This up. Late petition का.
2009.
2009. सबसे late patients रखे हैं ना.
We are
Then
just.
why do you have to, put unnecessary pressure?
No.
हो सकता है 3 महीना में अगर नहीं हो पाए, as per the procedure, you can mention it before the Honorable Chief Justice. Another bench will be constituted for this case. Isn't it? That is the procedure. So we are trying our best. इतना सारा contested matters रहता है. कुछ भी fact में error हो जाएगा, उससे अच्छा है कि 2-4 दिन late से ही दें. है ना? It's absolutely your choice. I don't want to say anything. I may not be able to deliver the judgment in 3 months.
I go with the.
It is quite possible.
I go with it.
Right? Because आपका तो सारा इतना सारा records रहता है. Arguments के समय बहुत सारी चीजें आपको point out भी नहीं करते. I'm getting lot of problems in deciding the cases because counsels are not placing the entire facts before the court. We take the words of the counsel
I go.
on the face of it as correct.
I go with it.
अगर मान लीजिए वैसा कोई प्रॉब्लम होगा तो भाई आप you have your own choice.
I go with it.
बट थोड़ा लेट हो जाए कुछ हो जजमेंट तो हम डिलीवर करेंगे
नहीं,
जरूर.
I
जब
go
तक
with
कि कुछ ऐसा ऑर्डर नहीं आ जाए कि हमको नहीं करना.
it. I go with it. I go with it.
From supplementary list, orders item 1 BS 6748 of 2026.
Withdrawal के लिए BA number 6448 of 2026. This petition and counsel for the petition. solicitor seeks permission to withdraw this bill application. Also, but the state has no objection to the prayer for withdrawing, accordingly this bill application is dismissed as well.
Sign kar. Permission item 3, DA.4027.2026.
Previous state was directed to file the supplementary affidavit of the seizure list as well as photocopy and check.
Where is the season list and photocopy of the check?
I am appearing on behalf of Bhushan Sarari or Sipol, whose application he was
So you are nobody, we are not interested. Where is the state?
Lordship Paso.
ACB.
Lordship Paso may kindly be given, she will be coming here. She is in DT. Paso office will be.
already seen on the party.
कोई बात नहीं, आपकी जरूरत ही नहीं है, ट्रैप केस में क्या करना है? You are not required for this trap cases. Right?
But taking this step by
Item 4, DA.5120.2026.
My lords, duly complying with my lord's order.
Item 4.
I have filed a counter affidavit. My lords may kindly take the affidavit.
You filed it?
Yes. On the 15th of July.
When was the trap done? It's a trap case?
Yes, Your Worship, it's a trap case.
When was the trap done? Who are you? What is your
Your
status?
Worship, yes, senior will do, he is a block supply officer, Your Worship. But senior will do, he virtually is there.
On the last occasion, my lords had asked
Sanction?
whether my lords, we have asked for the proposal for sanction, my lords, because that has been done, my lords,
Yes.
on the 12th of May itself, my lords. If my lords may kindly take the counter affidavit, it was dated 15th of July.
Serial number 4, I am appearing.
Yes, yes. Which paragraph?
My lords, para 4, if my lords may kindly see, my lords. That the instant supplementary counter affidavit is being filed in pursuance of order dated 9/7/2026 and in compliance of the same, it is submitted that the office of parties to
Paragraph 4.
Yes, my lords.
That the
But the
present case has
supplementary
supplementary count.
counter.
It's not on board. It has not been.
It was day before yesterday itself, my lords, it was filed.
It's not here. Okay, so the trap was
We have
made
submitted,
when?
my lords. We have submitted, my lord, that on the 12th of May 2026 itself, my lords, we have applied for.
It has gone to whom?
My lords, it has gone to the Secretary, Department of Food, Civil Supplies and Consumer Affairs, Jharkhand, Ranchi, for
Department
providing
of
prosecution sanction.
Civil supplies
And Consumer Affairs, Jharkhand, Ranchi, for providing prosecution sanction.
When was the trap laid? What is the date of the trap? 19/3/26. When was it? Charge sheet.
We have BA 5120
And when is
26 May supplementary affidavit file also
14/5/26. They say for sanction they have sent it.
5120/26.
Okay. And
Now, since
where
my
is that
lord-
order of the
वही केस चल रहा है।
division?
My lord, sir. My lord, this is my lord, sir. My lords may kindly take para 27, my lords.
This is Supreme Court order.
Yes, my lords.
27.
Yes, my lords. Para 27, my lord. The provision is there, my lords, which my lords is well aware of, my lords. First provision, my lords, I am reading before your lordship. Provided also that the appropriate government or any competent authority shall, after the receipt of the proposal requiring sanction for prosecution of a public servant under this subsection, endeavor to convey the decision on such proposal within a period of 3 months from the date of its receipt, provided also that in case where for the purpose of grant of sanction for prosecution legal consultation is required, such period may for the reasons to be recorded in writing be extended by a further period of 1
So this
month.
period is yet to expire.
Yes. My lord, so please, my lord's may put this matter at rest.
Yes, what do you have to say, Mr. Madhav?
Everything is here in the, he has demanded for motorcycle of 50,000 rupees. And that 50,000 rupees was recovered from his position. 40,000, sorry, 40,000.
That's
And what he has issued so far so that previous dealers.
for the learned counsel superior on behalf of the parties. The counsel for the petitioner submits that the petitioner, being the block supply officer, is in custody since 1926.
Yes.
1926. The charge sheet has been submitted on 14/5/2026 and sanction for prosecution has not yet come. He submits that the allegation is that the petitioner was demanding rupees 50,000 for the purposes of buying a motorcycle and 40,000 has been recovered. The learned counsel for the state by the learned counsel for ACB has submitted that the petitioner was apprehended red-handed with the bribe money after completing all the procedures. And on 12/5/2026, the matter has been placed before the Secretary, Department of Food, Civil Supplies and Consumer Affairs, State of Jharkhand for grand prosecution sanction. He has then referred to the judgment passed by the Honorable Supreme Court reporting in bracket 2023, bracket 1, section 29, and has referred to paragraph 27 thereof. Submit that.
And also, my lord's para 38.
Wherein it has been provided under proviso to section 19 that 3 months time is given to the sanctioning authority for grant of sanction, and if further legal consultation is required, then it can be extended by a period of 1 month. He has also referred to
Para 39, my lords.
para 39.
Wherein, my lords, Honorable Supreme Court said, my lords, that the period of 3 months extended by 1 more month for legal consultation is mandatory. The consequence of non-compliance with this mandatory requirement shall not be caution of the criminal proceeding for that.
The learned counsel has also referred to paragraph 39 of the same judgment to submit that the period of 3 months extended by 1 more month for legal consultation is mandatory. The consequence of non-compliance with this mandatory requirement shall not be quashing for the purposes of quashing the criminal proceeding for that reason. The competent authority shall be accountable for the delay and his action will be subject to judicial.
Yes, my lords. Which, my lords, the Honorable Supreme Court says in para 38, my lords, that the remedy would be to move before the writ court and ask for.
And it has also referred to paragraph 38 to submit that the remedy for the person aggrieved will be before the writ court. After hearing the learned counsel for the parties and considering the fact that the petition has been caught red-handed with bribe money amounting to rupees 40,000 being block supply officer, and charge sheet has already been submitted. The matter has been placed before the sanctioning authority on 12/5/2026. This court is not inclined to enlarge the petition on bail.
Your Worship, at this stage, this is already.
Actually, it is always at this stage.
It is already, because sanction has not come.
It is
and
always at this stage. It's always at
Because
this
he has already remained in custody for 4 months.
red-handed block supply officer. आपको पता ही है जाके
Item 5, DA5834 of 2026 along 36.
The state was required to counter affidavit, the same has not been tried. The specific query was with respect to the identification of the any victim and criminal antecedent of the present petition. since in the FIR, from the language of the FIR, there was no victim at all. And the only allegation which has been attributed as per the present petitioner is that there were certain APK files which were forwarded to unknown numbers. That's it. Any commission of offence has also not been attributed in the FIR.
There are numerous findings have been found against you. Numerous findings.
I don't think
Actually, you might not be knowing, but during investigation, so many crimes has come.
might be suspected ones, but none
Not
of them.
suspected one, they have also written letters to
No,
those
FIR has been
authorities.
registered.
Just a moment. They have also written letters to the authorities so that you can be remanded in those cases.
As far as this project is concerned, since I am not in possession of the counter affidavit or the document related to this,
We have the case diary here.
I cannot deny what has come on record.
Yes, it has come
I'll
on
just be
record.
placing what
So far as Kuldeep Singh is concerned, all the crime link, there are direct crime links, 4 of 4 in number in Maharashtra. And so far as Tinku Das is concerned, he has, I think, numerous crime links. I have to count how many they are.
I am appealing only on behalf of the first to the and the charges, the charge sheet has already been submitted.
And victims have been identified. It's there in the case diary.
Then that's on record, which is not in my possession.
That's right.
My
We do not know. And allegation is that you hack the phone and can have the control over the phone, and all the OTP goes to you, and you control the entire transaction through it. This is the allegation.
Yes,
This is the
I cannot dispute that, but from the FIR, what I can perceive is what my
FIR
information
is not encyclopedia.
Indeed, Your Lordship, but at this-
Investigation is still going on.
Indeed, Your Lordship, but charge sheet has been submitted. Investigation is complete.
BA number 5834 of 2026. Heard the learned counsel pleading on behalf of the parties. The learned counsel for the petitioner submits that as per the FIR. It said that the petitioner was involved in getting the APK file downloaded in the mobile of the victims. There is no further allegation. He submits that the petitioner has been falsely implicated in this case and he has no criminal antecedent.
And the charge sheet has been submitted.
And charge sheet has been submitted on
23/5/2026.
23/5/2026. You are for Kuldeep Singh?
Yes, Your Lordship.
The learned counsel for the state has opposed the prayer for bail and has submitted that numerous crimes have been found against the petitioner as has been recorded in paragraph 27 of the case diary. All of them are relating to Maharashtra and letters have been written to the authorities of the concerned district so that the petitioner can be remanded in those cases. He has also submitted that victims have also been identified. Paragraph
31 of it.
and has referred to paragraph 31
In serial 5.
of the case diary.
Serial 6 has written in para 32.
After hearing the legal counsel for the parties and considering the fact that, as per the allegation, the petitioner was involved in cyber offense whereby the petitioner should get control over the mobile of the victim and deal with all the transactions including OTP etc. Including obtaining OTP etc. The victims have also been identified who have supported the prosecution case, and there are numerous crime links relating to different states for which letter has been sent so that the petition can be taken on remand. In view of the aforesaid facts and circumstances, this court is not inclined to enlarge the petition on bail. Custody का क्या?
25 to 2026.
25 to 2026. The petitioner may renew his prayer for you after 8 months.
6 months का दे रहे हैं,
The
चार
state
training
is
कर रहे हैं.
expected to ensure that the requests are not being reduced before the court as and when they are called upon. Counsel for the state is directed to communicate this. Tinku Das. Same order. आपका withdrawal है पहले. You have withdrawn the case.
No.
हाँ Tinku Das का withdrawal है. Tinku Das का withdrawal है. Tinku Das, year number 5137 of 2026. Withdrawal नहीं अच्छा withdrawal नहीं ऐसे ही order लगा हुआ
इसमें वो जो भारत 31 की जगह भारत 30 हो गया
ठीक that's all it's a same ऐसे वो order ऐसे लगा दिया था government order तो उनको लगा दिया
From the list, model between Act 10, BA file number 13865 of 2026.
Yes, petitioner. I am there. Yes, what difference?
Other objection pointed out to stand or I think non-redacted copy of the
non-redacted copy of FIR. क्यों नहीं मिला? Did you apply for it?
No.
Where is the certified
copy? They redact करके ही मिलती है.
अच्छा वो certified copy भी वैसे ही है. ID number 9107 of 2026. The learned counsel for the petitions understand that the application has been filed to ignore the defect. With regard to filing of certified copy, which is non-redactable. He says that even the certified copy is being issued, which is redacted, and therefore the defects will be ignored. Considering the submissions IA number 9170 of 2026 is hereby ignored. However, the office is directed to call for a copy of the non-redacted copy of the FIR from the concerned. Committee post this case on the
Office filing item 16, BA 6420 of 2026.
Where is the petition? Monday and this. Petition absent for
Item 17, BA 6429 of 2026.
rejected, but the direction was given to prompt production of the witness. Till yet,
Where is the state? Are you appearing in this case? हम लोग को तो सर्कुलर आया था कि यहाँ पे 4 APP रहेंगे, क्या हुआ? सब गायब? Yes, we received a circular that for this code 4 APPs have been allotted.
10:45.
Where are they? कहाँ है? 4 APP का नाम हम बताते हैं आपको. कोड नंबर 11. शैलेंद्र तिवारी, विश्वनाथ रॉय, सुषमा एन, वंदना सिन्हा, राकेश रंजन. Why are they absent? आपके नाम की बात नहीं कर रहे हैं. यहाँ पर 4 लोगों को एलोकेट किया है. Why are they absent? तो इस सर्कुलर को क्यों हम लोगों को दिया गया है? तो हम क्या करें उसका? नहीं, ऐसे नहीं होता है ना. जब स्पेसिफिकली कोर्ट एलोकेट हो गया है तो 4 में से किसी को तो रहना चाहिए. इसका क्या मतलब है? एजी को बुला ले. कॉल दे. नहीं इस तरह से कोई बात नहीं. एजी को जरा बुलाइए. यू वांट टू नो फ्रॉम हिम. नहीं कोई बात नहीं. आस्क हिम टू जॉइन ऑनलाइन. यहाँ आने की भी कोई जरूरत नहीं. Counsel for the petitioner submits that the bail application of the petitioner was rejected earlier in bill number 1609 of the by order 1446.
एक केस के पास ओवर कर दिया जाए.
आज वो रांची में नहीं है.
एक केस के पास.
Madam, why you have been allocated this court?
नहीं इनका अपना.
तो फिर ये सर्कुलर का क्या मतलब? What is the idea of this circular? Should we throw it into the dustbin? 5 advocates का नाम दिया गया है who are being permanently attached to this court, and we are also told that भाई कोई भी appear होगा तो मतलब उसको accept किया जाए. ये तो 4-5 जने कहाँ हैं? सब लोग कोर्ट नंबर 4 में पहुँच गए. Yes, 5 persons. Where is Vandana Sinha? Where is Rakesh Ranjan, Sushma N, Vishwanath Roy, and Salim Tiwari? Are they absent? No, we want to know whether we should follow this circular or we should not follow. We are not interested. If you are not there, आपको bail देना हम दे देंगे. Why should I wait for you? I will not wait for you.
They have been allotted this and they should be there. This one.
They are not here. They are not here. आपको बेल देने में कोई दिक्कत थोड़ी है. आपके एब्सेंस में भी दे सकते हैं.
They should be there. I'm asking.
Yes, why the witnesses are not being produced? File the affidavit of the SP as to why he has not complied with this order.
वहाँ पे नाम की जगह वही लिखना
BA
पड़ता
number
है.
1609 of 2026. Sorry, BA number 6429 of 2026. The counsel for the petition submits that the bail application of the petitioner
कोई
was
फोन करेगा ना.
on 1/4/2026. And it was stated therein that no prosecution witness has been examined. अभी कोई भी नहीं examined. And there was a direction to the state to promptly produce the witnesses. And the learned counsel for the state was directed to communicate the order to the director of prosecution as well as to the superintendent of police of the concerned district to ensure compliance. In that case, Mr. Rakesh Kumar Sinha, on Rakesh Kumar Sinha, was appearing as on behalf of the state. The counsel for the petitioner submits that, in spite of direction, not even one witness was turned. कितना dates हुआ? कितना dates हुआ? And as per his knowledge, 3 to 4 dates. On 3 to 4 days, the matter was posted. for instance. Office is directed to call for the entire order sheet from the unit board right from 1/4/2026 onwards. And also the present stage of the case. The learning council for the state is directed to seek instructions and file an affidavit of the SP of the concerned district as to why the order dated 1/4/2026 has not been compliant. SP का affidavit आना चाहिए. Close this case on the first.
Item 18, BS 6456 of 2026.
Since when are you in custody? Counsel for the state is directed to serve notice upon the victim. Call for case diary from the concerned court along with the enclosure and the statement of the victim.
काउंटर एफिडेविट फाइल किया है.
वो तो देख रहे हैं कैसा काउंटर एफिडेविट फाइल. क्या लिखे हैं आप काउंटर एफिडेविट? अपोज करने वाला कोई बात लिखे?
एज है इनका 17 साल.
तो इसके अलावा क्या लिखे? क्या मटेरियल है आपका इन्वेस्टिगेशन में?
इंडिपेंडेंट विटनेस सपोर्ट.
ओके. इस तरह का स्केची कॉन्ट्रैक्ट फाइल के लग रहा है कि बेल हो ही जाएगी ज्यादा ठीक.
सीरियल नंबर 13.
Notice to victim आपका लिए call for the CD from the concerned court with enclosures and also the statement of the victim recorded under section 183 BNSS and also the state of the case. कोई काम 18 से कम है ना?
हाँ जी जी.
पोस्ट ऑन रिक्वेस्ट.
नोटिस करेंगे.
विक्टिम को नोटिस करिए.
जी जी.
काउंटर फाइल किए उसमें लिखे हैं कि विक्टिम को नोटिस कर दिए हैं? नहीं लिखे हैं ना? कुछ नहीं लिखे हैं काउंटर एफिडेविट में. आपके पास केस डायरी आया है?
जी उसमें वही.
केस डायरी आया है आपके पास? ठीक है. नो कोर्ट से मंगाएंगे.
Item 19, BA 6457 of 2026, 31st.
In this case, CD has been called for, and there are several cases.
ये तो दूसरा केस में कौन से दिन में फंसते हैं?
29 साल.
29 में.
APA number 5908.
26.
Yes. Several other cases.
BA number 6457 of 26. At the request of the counsel for the petitioner, that this case is BA number 5908 of 2026, which arises out of the same FIR. And post on 29th of July 2026. The learned counsel for the state is elected to file counter affidavit along with the criminal antecedent report prior to the investigation.
Item 20, BA 6458 of 2026.
The allegation is that the victim has died due to hanging. She had due to hanging and the petitioner was not in the town. He was in Chhattisgarh. And as per the court report also, his location was found on Chhattisgarh.
That's so she committed suicide, right? Since when are you in custody?
25 to 26.
25 for 26. You are the husband.
Yes.
The incident happened in 2025. Where were you?
I was in Chhattisgarh.
आपकी वाइफ मर गई आप छत्तीसगढ़ में बैठे?
But I was working there. My My call record was also.
I just want to know, the wife has expired, you were in Chhattisgarh. For how many months? You did not cremate your wife also?
After that I came back, but during the course of that, I was in Chhattisgarh.
That's right. तो इतना दिन कहाँ थे? 5 महीना, where were you?
Yes, I remember.
Not necessary. When was the marriage solemnized? Sorry, this is a tied up matter. अच्छा, ABA था. ABA was before. When was the marriage solemnized?
27/8/20.
27/8. When did the bride die? Date of death बताइए. 27/8.
Yes.
No. When did she die? What is the date of marriage? She died on 27/8. What is the date of marriage?
Date of marriage.
Husband को नहीं पता था. कितना दिन हो गया प्रैक्टिस करके? Counsel by the state is directed to serve notice upon the informant of the case and file a contract with it. इनके लिए तो चार्जशीट हो चुका होगा आपका. ये रखी जाएगी along with its enclosures, the call for from the concerned court including the postmortem report of the victim. Counsel for the petitioner undertakes to file a supplementary affidavit disclosing the date of marriage of the petitioner with the deceased. Affidavit filed. Post this case on 5th of August. The needful be done by the court.
1921 DA646 for alternative.
Allegations are under section 12 of the POCSO Act and other available sections of the BNS.
Investigation is going on. अभी तो चार्जशीट नहीं हुआ.
Your Lordship.
क्या करें?
Case diary may be called for, Your Lordship. Actually, from the school records, the age of the victim is more than 20 years on the day of occurrence. I have annexed Annexure 3, page number 15 and 16. And rest all the sections are available in nature. Main allegation is over the co-accused person, Upendra Yadav.
चार्जशीट क्या? अभी तो चार्जशीट हुआ ही नहीं है, पता ही नहीं है.
Your Lordship,
No
case
video has
diary,
been recovered.
nothing has been recovered.
Video has not been recovered.
No, nothing. In fact, the informant appeared before the court bureau and reported that she does not want to pursue the case as she was not knowing
In a
that.
statement under section 183.
No, Your Lordship.
You order में ये support कर रहे हैं.
नहीं, ये जो कहानी बोल रहे हैं वो लिखना पड़ेगा ना.
And सभी बेल का रिजल्ट हुआ तो उसमें आया हुआ था कि informant compromise कर चुकी है, उनको पता था कि भैया तो जो है इसमें इस particular petitioner के ऊपर ऐसा allegation है जो co-accused है उसके ऊपर allegation है कि उसका affair था victim के साथ और victim का शादी कहीं और हो रहा था तो फिर वो इसको बाइक से लेकर गया था और धमकी देकर आया.
Learning counsel for the parties are present. The learning counsel for the petitioner submits that as per the school records, the victim is minor. And no video has been recovered. No video or any incriminating material like photograph, etc. has been recovered. The counsel has submitted that the petitioner is in custody since 2/6/2026 and investigation is going on. But he insists that the case diary may be called. The counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit. In this case, let the statement of the victim recorded under section 1 be called from the concerned court. The state is directed to produce the case diary before this court. Up-to-date case diary before this court with all its enclosure, including a medical examination report of the victim. Post on 10th of August. The needful be done by the state by 5th of August. तब तक आ जाएगा आपका case diary please.
Item 22, PA 6462 of 2026.
Election yes case 167/26 registered under section 100 384 2019.
You are a student?
Yes, student madam.
Caught red-handed?
हम लोग स्टूडेंट हमारे एग्जामिनेशन चल रहा था तो इनको सस्पिशियन हुआ कि कर्सर ऑटोमेटिक चल रहा है, ऑनलाइन एग्जामिनेशन चल रहा है, तो हमको सस्पिशियन में हमको अरेस्ट किया गया, बाद में क्वेरी किया गया सारे डिवाइसेस।
इन्वेस्टिगेशन भी कंप्लीट नहीं हुआ, कस्टडी आफ्टर 10
सारे डिवाइसेस हैज बीन रिसीव्ड बाय द एजेंसी और मैक्सिमम इन्वेस्टिगेशन हो चुका है। हम 2 साल 2 महीने मोर देन 2 मंथ्स से
यू आर बीन कॉट रेड-हैंडेड एग्जाम में चोरी।
हाँ, तो ये हमारे सस्पिशन है, उनको सस्पिशन था कि ये हैक किया गया हैकर के द्वारा।
जब तक आपका कन्विक्शन नहीं हो जाए तब तक सस्पिशन ही रहता।
हाँ
वो तो है ना।
तो फिर किस इंटीमेटा में केस डायरी कब से कॉल करना
नहीं नॉट रिक्वायर्ड।
इन्वेस्टिगेशन तो कंप्लीट हो गया है,
अभी ऑलमोस्ट कंप्लीट और कंप्लीट में भी
हाँ कंप्लीट पूरा नहीं हुआ है।
ठीक कोई बात।
हमारा कोई फिजिकल एंटीसीडेंट भी हो गया नहीं है मैडम।
अच्छा है एंटीसीडेंट नहीं है, नहीं तो एग्जाम भी नहीं दे सकते, अब तो डिस्क्लोज करना पड़ता है एंटीसीडेंट है।
अब हम लोग का फर्दर कोई एग्जामिनेशन में अभी क्लियर नहीं कर पा रहे हैं, हम लोग इसको कैरियर का बात इसको कंसीडर किया जाता है। हम कोऑपरेट करने के लिए इन्वेस्टिगेशन कोऑपरेट करने के नाम ऐसे हम करेंगे, उसको नहीं करेंगे उसको हम पहले भी किए हैं और अभी भी करेंगे, कंडीशनल दे दिया गया कंसीडर। I am ready to cooperate in this investigation. Whatever investigation is going on.
What the learning council is doing right now, the learning council for the petitioner submits that the petitioner, while giving the exam, was happening with the allegation that while he was giving the exam, his online system was remotely hacked. And there was bumping in the examination process. He was arrested on the spot and sent to police custody. He is in custody since 10/2026.
10 पाँच
10 पाँच
डेढ़ में जाइए, 1:30 बजे।
The petition submits that the charge sheet has not yet been submitted. Investigation is going on, but all the materials, that is computers, etc., have been seized. The learning council for the state has opposed a prayer for bail, and they submitted that the investigation is going on, and it is a case of large-scale bungling in the examination process, and the petitioner was caught with. After joining the learning council for the parties and considering the serious nature of allegation, and the investigation is still going on, the court is not entitled to announce the petitioner has been instituted.
at this stage.
Sir, please at this stage.
Item 23, PS 6619 of 2026.
Your Worship, this is an earlier rejected matter. The rejection order is on page number 19. And we wait only 2 witnesses having examined. The seizure list witnesses have also been declared hostile.
ये वाला सब उठा के ले आओ।
That is annexion 3.
हाँ ले आओ उठा के, ऊपर वाला छोड़ देना खाली खुला।
And the petitioner is in custody since 13/9/2024.
Yes, what you say? 17 February 26 के बाद क्या हुआ? After 17 February 26, when the bail application was rejected earlier. How many witnesses have been examined thereafter? Not even one witness has been examined.
The Pune order is at page number 23, which is dated 16/5/2026, and it has been mentioned that only 2 witnesses have been examined out of 6.
So the counsel for the petition submits that the bail application of the petition was rejected earlier on 17 February 26 in Bill number 10562/2025. At that stage also, only 2 witnesses out of 6 were examined. She submits that as per the Pune order dated 16/5/2026, no further witness has been examined. The perusal of the order dated 17 February 2026 reveals that the state was directed to ensure that the witnesses are promptly produced. It is not clear from the records as to why the witnesses have not been produced. The counsel for the state is directed to seek instructions from SP Latihani and file his affidavit before the court as to why the witnesses are not being produced before the court. It has now become a ground for the petitioner to renew his prayer for bail. Let the entire order sheet of the particular report right from 17 February 2026 be also called for. उनका affidavit file कर दीजिए. And I want to record that it is because of the SP they are being released. And it should go to their home department. Something has to be done. You cannot have it like this. Witness से produce करेंगे और accused को जेल में रखेंगे. दोनों चीज नहीं हो सकती. जितना भी ये ऑर्डर होगा ना, where SP is not producing the witnesses, it will be communicated to the home department. Maybe Ministry of Union Ministry or whatever, wherever. That should form a part of their service record, isn't it? They are instrumental in getting the accused released on bail by not producing witnesses, isn't it? Pose this case on 31st. The counter affidavit should be filed. The counter affidavit of the SP should be filed by 29th. So previous counsel थे उनसे पूछ लीजिएगा communicate किए थे नहीं किए थे क्या थे.
Item 39, BA 5235/2026.
Where is the petition?
Item 39.
Earlier withdrawal, another 3 accused have been granted bail and remanded in this case from another case.
There are how many antecedents?
3 more other antecedents.
3 more antecedents. And you have been caught red-handed?
No, Your Worship, I am remanded in another from another case.
Maybe. Achha, you have been remanded from another case?
Yes, Your Worship. And other accused has been granted bail, Your Worship.
Maybe the state is absent. Since when are you in custody?
On 16/10/2025.
What is the stage of the matter?
Evidence.
How many witnesses have been
5
examined?
witnesses have been examined.
Show me the office. The informant was examined as a witness at the stage of trial. Has he identified? Because in the other cases, it has been mentioned that the informant has not identified what she from where you are getting this. Again, it's a copy of his evidence.
बैग में वो भी देख लेते हैं.
For the Learning Council's opinion on behalf of the parties, the Learning Council for the petition submits that the petition is in custody since 16/10/2025 and the three co-accused have been enlarged on bail by following judges. Jaikumar by order dated 16/4/26. Ranjan Kumar by order dated 19/6/2026. One criminal division also, that he must be doing 90. And one Megna Kumar in criminal division number 260/2026 by order dated 6/2026. आपको क्या बोलना है? The Learned Counsel for the state has submitted that the name of the petitioner transpired in the course of the investigation and he has 3 witnesses. After hearing the Learned Counsel from the parties and considering the fact that other 3 co-accused have been enlarged on bail by the concerned courts, by this court, as mentioned above, and the custody of the petitioner since 16/10/2025, the petition is
Item 40, DA 5.7.4 of 1026.
कोर्ट से रिपोर्ट मांगा गया था. एक साल हो गया कस्टडी में, कोई
लास्ट नो ऑफिस नोट पढ़िए ना.
और जो एक मोबाइल 1 सिम है, एक प्रीवियस एंटीसीडेंट था और कस्टडी 4/8/25 से है. 13 चार्जशीट विटनेस है. टिल डेट विदाउट ओनली 2 विटनेस हैज बीन एग्जामिन्ड.
appelling of bail.
Yes, yes.
You have withdrawn the case.
Annexer 1 is also वो एक का भी बेल मूव हुआ था विदाउट डेट.
Annexure 1 is the order.
Yes.
Annexure 1 पे लिखा है ये BA number so.
Yes, same. Earlier, since there was antecedent, one antecedent was there.
क्या बोलना है?
और इनका भी बेल हो गया.
एक witness examined. Custody of
4/8/25.
4/8/25. Only one witness has been
2.
examined.
I have said 2 out of 13.
Two out of 8.
Charge frame है जनवरी 20/1/26.
इसको भी हुआ.
राजेंद्र दास इनका भी ये हुआ था. इनका भी एंटीसीडेंट था, इसलिए कोऑर्डिनेट बेंच.
क्या बोलना है बताइए? Only one antecedent.
Yes, one.
For the Learned Counsel opinion on behalf of the parties, the Learned Counsel for the petition submitted the bail application of the petitioner was rejected on notification of 160 of 5 by order dated 16/3/2026. Primarily on the ground that the petitioner has one antecedent and victim was also identified. He submits that the petitioner is in custody since 4/8/2025, which is almost 4/8/2025. The charge was filed on 4/8/2026. And the accused Rajendra Das has been enlarged on DA number 3930/26 by coordinate bench. after hearing the learned counsel for the parties, and considering the fact that the petitioner is in custody since 4/8/2025, and as per the report received from the concerned court, only one of this witness has been examined till date.
One more हो गया.
And counsel for the petitioner has admitted that 2 witnesses have been examined so far. Considering the custody and the fact that the court use has been enlarged and the petitioner is directed to be
Item 41, BA 6.2.5.2026.
Division under section 20, so far indication is that there is a demand of 5 lakh rupees and
What?
I am Sasu. Bigger Mahpur is Sasu and then Sonu is specific regulation.
What is the date of marriage? Marriage. The date of marriage.
No man of the I am so far the issue is concerned. मेरी बेटी मीना कुमारी को ससुराल वालों ने दहेज में 5 लाख रुपये तथा एक बुलेट बाइक जबरन मांग कर रहे थे.
Who is Bunty Kumar?
Yes, ma'am.
Bunty Kumar. Who is Bunty Kumar? Who is Bunty Kumar?
Ashok Kumar.
Bunty Kumar कौन है? Your father?
Informed. Bunty Kumar is the one who helped at the time of commission of the office.
He has been enlarged.
He has been enlarged at the time.
At the time? That's right. Perfectly all right.
But
He was enlarged.
उसके against the confession statement में आया है that he had helped जब वो काबू में नहीं आई तो he had helped कि वो पैर पकड़ा. Thereafter अशोक कुमार ने been accused है उसने उसका bail reject हो गया.
Ashok Kumar's bail has been rejected.
And thereafter legal matter against allegation कि he was acting as a lookout. कोई भी person trying to witness things.
He was present. He was present at the place of offense.
He was present as per the confession.
The incident had happened at home.
At home, he was present. He was acted as a lookout, so that nobody can witness the crime. As per the case diary and confession statement of his wife and his son.
FIR पढ़ती.
मेरी बेटी दहेज प्रताड़ना का कारण माँ की ससुराल वालों के द्वारा किया गया. हमने बीच में संध्या बिठा दी थी. इसके बाद भी ससुराल वाले धमकी देते कि अगर 5 लाख रुपए की कोई बुलेट बाइक नहीं देगी तो मेरी बेटी के जान से मार दो. आज दिनांक के 3/26 को समय करीब 7 AM सुबह में मुझे दूसरे लोगों ने मेरा सूचना मिला.
अभी देखेंगे मैच को उसको बढ़िया लिख लेंगे जाएंगे उधर के
मेरी व्यवस्था मेरे प्रत्येक में पड़ी. ससुराल वाले
तब शायद कब होगा ये मैंने बताया.
विश्वास है यशु नाथु पिता दिगम नाथु ससुर दिगम नाथु प्रेजेंट पिटिशन शंभु नाथु सास राधा देवी दिगम नाथु ये तीनों राजश्री हमारी बेटी मीना कुमारी को हत्या कर दी.
और हस्बैंड को bail हो. The family members ने भी किसी को
Except
Bunty is the family member.
he is also a family member.
इनका क्या relation है Bunty?
Some
A relative.
a relative.
heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner happens to be the father-in-law of the deceased
देते हैं 5
and
5 देते हैं
there is general and omnibus allegation against all the family members with regard to demand of dowry. During the course of hearing, it is also displayed that the deceased died unnatural death within 3 months of marriage.
आए चाहिए
Within 3 months of marriage.
समझेंगे जो
The petitioner is in custody since.
Just screenshots.
हमको बोल
And date of incident is date of incident. And the date of occurrence is 1/3/2026. They submitted that the accused named Banti Kumar has been enlarged on bail by order dated 4/6/2026 by employment. Banti Kumar happens to be a relative cousin of the cousin of the husband of the deceased. The learned counsel for the state as well as the informant has opposed the claim of bail and have submitted that there is direct allegation with regard to demand of dowry and torturing of the deceased. After hearing the learned counsel for the parties and considering the fact that deceased died a natural death in a matrimonial home within short time of marriage, this court is not inclined to enlarge the petitioner on bail hence rejected. Marriage is in the month of May 2025. Marriage was performed in the month of May 2025. She died in a matrimonial home on 1/3/2006. FSL report. इसका वही FSL report is important. पढ़ा हुआ है वही.
Paso case from supplementary list item 3, BA 4027/2026.
Where is the photocopy of the cake?
Yes, sir. So
When you have check, 20 lakh.
20 lakh without any name and date.
He has taken as security.
ये signature किसका है?
चलन सिंह सरदार
Informant का.
Informant का है और एक उसके
एक और
चाचा
चेक
है।
एक और चेक है।
इनसे आप चेक क्यों नहीं?
एक पैराग्राफ पेज नंबर 15 है बड़ी फ्री टैप मेमोरेंडम में आया है दिस चेक हैज बीन रिसीव्ड ऑन 24/2/2026 एक महीना पहले ट्रैप हुआ है 23/3/2026 आफ्टर 1 month it has come in page 15 kindly see page 15 of my उल्लेखनीय है कि सत्यापन के क्रम में पेज नंबर 15 Page number running page 15 of my bill application. इसमें उल्लेखनीय है कि सत्यापन के क्रम में आवेदक के द्वारा बताया गया कि 24/2/26 को बड़ा बाबू प्रीतम आचार्य एंड विनय तिवारी के द्वारा रिश्वत लेने के का दबाव बनाकर 20-20 लाख का 2 SBI का चेक नंबर 700 तो आवेदक के खाता नंबर 700 एवं दूसरा चेक नंबर 700 जो कि ठाकुर सिंह सरदार के खाता नंबर 700 से संबंध में संबंधित है तो अग्रिम सिक्योरिटी
के रूप में
ये that has come in the record. It is in pre-tax memorandum. The check has been received on 24/2/2026, 1 month before the tax losses. और This is a matter of fact. It has become in the Bada Babu ke निर्देश. Demand was made by the Bada Babu, who was the head clerk of land acquisition office. कुछ हम गया तो उसको ट्रैप में हम मेरे पॉकेट से रिकवर करवा दी. That is
वो करवा दिए.
the main concern.
कौन करवा दिए?
I'm not going to that also. ये तो that is लेकिन वो जो main को accused हुआ जिसके डिमांड से सारा एलिगेशन he has been targeted.
उसके यहाँ से कुछ रिकवरी नहीं
उसके पास रिकवरी
इसीलिए उनको बेल हुआ.
बेल तो इस ग्राउंड पे हुआ कि जो compensation has already been paid before the trap.
बेल का ग्राउंड है कि उसके पास कोई रिकवरी.
यही ग्राउंड है. यही ग्राउंड है कि उसके पास से कोई रिकवरी नहीं. Evidently, no cash was recovered from the possession of the petitioner and he is in custody since 24/3/26.
इसमें आगे submitted an advance running cost prior to lodging of the first information report. The beneficiary had received the share of compensation and thereafter admitted no cash advance. These are the two rounds of guarantee bail of the co-accused. And so far as charge sheet has been submitted, it is pending for the sanction order. All together, petitioning
sanction order में अभी आ गया 3 महीना में आना है.
24/3/26 more than 3 months is lapsing in jail custody also. और हम स्टेटस रिपोर्ट सप्लीमेंट्री एफिडेविट में लगाए हैं लोग. उसमें चार्ज शीट has been submitted.
When?
So charge sheet has been submitted on 18/5/2026 itself. 18 altogether 15 witness charge sheet witnesses there also. And thereafter kindly see annexure B of my supplementary affidavit also. इसमें awaiting for sanction order दिखा रहा है. Next date of
sanction के लिए अभी सुप्रीम कोर्ट का जारी 3 महीना टाइम तो बाय डिफॉल्ट ही दिया हुआ है. उसके अलावा 1 महीना टाइम दिया हुआ है. 18/5/26 को चार्ज शीट हुआ है तो उस समय क्या होगा sanction के लिए. अभी तो शॉर्टली अभी तो sanction के लिए आप नहीं बोल सकते कि sanction में ये किया.
petitioner is lapsing in custody 24/3.
Land acquisition का पैसा
I was brought of the my main allegation that I was brought of the Bada Babu.
तो और भी सीरियस बात है.
Main allegation
ना देना फिर भी
मेरे ऊपर जो डिमांड का एलिगेशन नहीं होगी. The best case against me I was at another place गमरिया ब्लॉक में वो भी नहीं हम वहाँ से गमरिया ब्लॉक में रेडिंग टीम रिलेटेड है और वहाँ फिर मेरे पास से चेक मेरे पॉकेट से निकाला. That is allegation against me.
और इनके पास से क्या मिला?
और ये चेक मिला है करेंसी नोट्स.
Currency notes 5 lakhs currency notes were found. There was any demand of 5 lakhs?
So it is a part of demand.
It's a part.
मांगा तो 40 लाख है. उसके
लेकिन ड्राफ्ट में तो पहले से मेमोरेंडम बना के फिनाक्टिलिन पाउडर लगा के
ये लगा हुआ है. ये पूरा लगा
है. 5 lakhs का जो रिकवरी हुआ है it is stated money और ऐसे ही
टेंटेड मनी.
कहाँ
ये प्री
ड्राफ्ट मेमोरेंडम में 5 lakhs है.
5 lakhs.
Where is that?
Demand has been made by the other co-accused, not by me.
Recovery आपके पास.
Recovery मेरे पास है लेकिन demand is not made by me. ये kindly देखा जब पेज नंबर 14 में
आपके पास से 5 lakhs tainted money recovered.
उसमें एक बार लास्ट पैराग्राफ kindly see पेज 14. सत्यापन के क्रम में दिनांक 20/3/26 को समय 11:30 बजे आवेदक और उनके परिचित के साथ भू अर्जन कार्यालय सरायकेला पहुंचा, जहां आवेदक एवं उनके परिचित द्वारा बड़ा बाबू प्रीतम आचार्य का कोई बड़ा बाबू प्रीतम आचार्य से मुआवजा के संबंध में बातचीत किया गया, जहां पर बड़ा बाबू प्रीतम आचार्य के द्वारा आवेदक को रिश्वत की रकम 40 लाख रुपया विनय तिवारी को देने के लिए कहा गया. डिमांड हैज बीन मेड बाय द अदर कोई देन आफ्टर आवेदक एवं उसके साथ गए मुबारक हुसैन को डब्लू द्वारा बड़ा बाबू से पूछा गया कि कोई दिक्कत तो नहीं है. नहीं होता तो बड़ा बाबू प्रीतम आचार्य के द्वारा कहा गया कि कोई दिक्कत नहीं होगा, जाकर आप विनय तिवारी को पैसा दे दीजिए. उस पर आवेदक ने कहा कि पहला किस्त 5 लाख रुपए देगा. इस प्रकार बड़ा बाबू प्रीतम आचार्य के विरुद्ध लगाए गए आरोप सत्य. So it is a matter of fact of demand was made by the co-accused. I was just paid as an instrumental. And the co-accused has been granted bail.
As per the allegation, demand was made by the co-accused, and and at which the petitioner played the role of being an instrument in the alleged offence. He submits that the petitioner is in custody since 24/3/2026. The charge sheet has been submitted on 18/5/2026, but no sanction for prosecution has been received so far. The learned counsel has also submitted that the accused, namely Pritam Kumar Acharya, who had made the demand for bribe, has been enlarged on bail in bill number 4434 of 2026 by the order 2026/2026. The learned counsel for the state has opposed a prayer for bail and has submitted that Pritam Kumar Acharya has been enlarged on bail primarily on the ground that no cash was recovered from the possession of Pritam Kumar Acharya. Rather, there has been no recovery from the possession of Pritam Kumar Acharya. It is just a prohibition case. He has submitted that rupees 5 lakhs paid money was recovered from the possession of the petitioner and a supplementary affidavit has been filed. Claiming on the account two checks of 20 lakhs rupees each, signed by the petitioner, signed by the informant and his family member, which was found in possession of the petitioner at the time of the crime, which was a blank check, and apparently it was by way of security so that the bribe money is paid. After hearing the learned counsel for the parties and considering the fact that the petitioner was caught red-handed with bribe money and a proceeds from blankets were also recovered from his possession, this court is not inclined to enlarge the petition on bail. So far as the bail of co-accused is concerned, admittedly no recovery was made from the co-accused, and therefore the case of the petitioner stands on different footing. However, the petitioner will renew his prayer for bail after completion of custody of 1 year.
At least some observation on behalf of custody by
I think इस तरह के cases में 6 महीना custody sufficient है आपको ठीक लग रहा है। आप 1 करोड़ का compensation में 40 लाख रुपए आपको bribe
demand to मेरे अगेंस्ट that is not eligible.
सभी को मिल बांट के खाना है ना।
मेन एप्लीकेशन के ऊपर
तो आप उसका चेक लेके क्यों पॉकेट में डालते?
From supplementary list for final disposal item 2, the rupee 599 of 2026.
So in this case, also the respondent number 2 has died or also then
Who is respondent number?
there is 2 respondents from 2 and 3.
Oh, bail service में आते हैं। The learned counsel for the petitioner submits that respondent number 2 has expired. Who minded this?
On state one.
Respondent 3 has appeared.
Who will be at the private one in the state.
So you को तो आप you have to take steps ना? Take steps with respect to respondent. Counsel for the petitioner
The execution procedure चल रहा है और उसका
क्या करें?
ये जो ex parte judgment है और क्योंकि जिस पर जहाँ कहते हैं कि they are working वो गुरुकुल का 2016 में ही वो एक्वायर्ड हुआ देवर रिपोर्ट के लिए वो डिमोलिश हो गया बिल्डिंग।
अच्छा एग्जीक्यूशन में क्या कर लेंगे? वहाँ का क्या उखाड़ लेंगे?
तो वो दूसरे प्रॉपर्टी को ही कर रहा था दूसरा
कहाँ अटैच किए हैं अभी तक?
तो उसके लिए इशू किए हुए हैं रीट इशू किए
कहाँ है? Where is that order?
नोट से मंगाए थे इंटायर ऑर्डर शीट एक्यूशन का मुझे मंगाया
कहाँ है? कौन सा ऑर्डर है? बताइए दूसरा प्रॉपर्टी को कर दें। बताइए। Which is that? फिर हम तो पढ़ा ही नहीं रहे। कौन सा ऑर्डर है? लीजिए, एग्जीक्यूशन केस का ऑर्डर हम आपके लिए मंगा रहे हैं क्योंकि आपके साथ में फाइल नहीं थे। निकालिए। कुछ नहीं हो, ऐसे ही चल रहा। सब्स्टिट्यूशन करते हैं, सब्स्टिट्यूशन करते हैं। नेक्स्ट फाइल है, एक्शन सीक्वेंस प्रोसेस के सब एक सेकंड। एग्जीक्यूशन में कौन दोनों थे आपके एक सेकंड। देखिए एग्जीक्यूशन देखिए आपके फाइल
ऑर्डर चला सर
कौन फाइल के रेस्पॉन्ड नंबर 3 रेस्पॉन्ड नंबर 3 इलेक्ट्रोड डिस्क्रिप्शन रेस्पॉन्ड नंबर 3 रेस्पॉन्ड 3 आपके हो हां एग्जीक्यूशन से रेस्पॉन्ड नंबर 3 बताइए। हां सिर्फ 3 फाइल कहां है? वेयर इज रेस्पॉन्ड नंबर 3? लास्ट डेट में अपीयर किया ऑनलाइन। The counsel for the respondent number 3 is absent. It is respondent number 3 who is person who has filed the execution case.
ये 15-60 दोनों में ये दोनों कहाँ हैं?
आइए बैंक में at this the counsel for the petition pays for stay of execution.
उसके लिए 15-60
In the next state, that is till Friday, the further proceeding and execution is under such and such, which are related to the substitution by the legal university.
From PV list, orders be defined item 3, first appeal file number 7093 of 2025.
Money source. Appellant absent. Time till 29th July is granted to the appellant to remove the surviving defects / to file interlocutory application in connection with one or the other defect. Frame 29 and 31st February. If this order is complied within time, goes this case on 5th of August. Since the counsel for appellant is absent, office is directed to forward a copy of this order to the counsel for appellants.
Item 4, first appeal file number 8990 of 2025.
Lordship, and paying for which time for development.
Time till 14th August is is granted to the applicant to remove the surviving defects or to file appropriate petition in connection with one or the other defect. Print. If this order is compliant, within time, office is directed to place this case on the application on 19th of August.
Item 5, first appeal file number 10309 of
Review
2025.
appearance. Appearance detail. Memo of appearance.
स्लीपर कहाँ फ्लिप लॉक है यहाँ रखो दो इस पे रखिए छोड़ दीजिए
Time till 31st July is granted to the applicant to remove the surviving defect print. If the defects are removed within time, post this case on 5th of August in the application. Petitioner absent. Let a copy of this order be forwarded to the council public. A soft copy be forwarded to the council public petition file will be for compliance.
Item 6, first appeal file number 12939 of 2025.
Time till 14th August is granted to the applicant to remove the surviving defects. If the defects are removed in time, post this case on 19th of August.
Item 7, contempt civil 15392 of 2025.
For two. Certified copy of improvement. I can. What we prefer one?
Time till 24th July is granted to the petitioner to remove the surviving defects print. If the defects are removed within time, office is directed to place this case on appropriate time of the defects.
31st July. Next date.
31st.
Next date.
Time इन्होंने एक हफ्ता मांगा है तो वेट करता है 24 घंटे.
Item 8, first appeal file number 1824 of 2026.
Yes,
One of the defects will be removed from corrected by the group below. Defect number 99. Valuation in the appeal and in the award has not been mentioned. Other defects, two, three defects will be removed by the.
Which defect number?
99. Accepted 87.
Appeal value may be given.
Appeal value and that is in the award also appeal value has not been mentioned.
Suit value is missing in the CC of the award. The learned counsel for the applicant has submitted that the improved award is required to be sent back to the concerned court. Where is the award?
Your subsequently aspect.
Is required to be sent to the concerned court for correction, in as much as valuation has not been mentioned.
Judgment differs from the award.
Judgment differs from award.
This is the official 99. Valuation, appeal value is missing, incomplete.
Is missing now.
And it is incorrect. So value, appeal value.
Counsel for the office is directed to send back the judgment and the award. Judgment will is there.
Yes.
At the request of the counsel for the applicant, office is directed to send a certified copy of the judgment and award to the concerned court for necessary correction. The office shall indicate the corrections which are required to be made by the concerned court. So far as other defects are concerned, the appellant is permitted to remove the defects within 3 weeks. Post this case on 22nd August.
Item 9, first appeal file number 3028 of 2026.
When we have a neutral last order.
Yes.
My friend has already referred Calcutta regarding maintainability, but this time reported that whether the gross objection filed in a suit is maintainable or not. That says both the matters, partition suit and probate case, were tagged together and to be heard by any judge by this. Okay.
Where is that order? Where is that order?
Yes.
They were directed to be heard together.
By this.
So now the order passed is by ACT.
Whatever that every person's died, substituted. Substituted is filed written statement, additional written statement on. We have.
We are only on the maintainability of this case.
Hey, I'm reading that maintainability of this case, right? We have already cited Calcutta Jail. Okay.
What does it say?
It is a decree. Read the last 3 paragraphs. After referring some judgment, read paragraph 15 and 16. Since revision was filed before Calcutta High Court and the matter was reported that revision is not maintainable. Since it is a decree.
So according to you, the improved order is a decree.
Is it?
And therefore the appeal would lie. The appeal would lie as far as the pecuniary jurisdiction is concerned.
No, that is
appeal will lie before this court. Because of ACJ's order.
AC. And
we will ignore the defect. We will ignore the defect. Subject to any objection which may be raised. For the present, we will ignore. That should be sufficient. अगर वो आके कुछ objection करते हैं तो आप फिर क्योंकि अभी तो वो है नहीं यहाँ पर।
नहीं, प्लेटिव तो हम ही लोग के रिलेशन।
कोई बात नहीं, नोटिस करेंगे तब ना अपील होंगे बोलेंगे। बिना नोटिस के तो अपील नहीं होंगे ना?
नहीं, ऐसे तो आप इसको पेंडिंग रखा है।
नहीं, इसको ऐसा कर रहे हैं, इस डिफेक्ट को अभी इग्नोर कर देते हैं, subject to any objection that may be raised.
In the meantime, we will notice.
Yes.
And will have non-judgment of your lordship disputed.
ये तो हमको वही हमको याद आ रहा था।
I would say not be careful. And we have prepared a note on facts.
इसको अभी थोड़ा सा इसको कर देते हैं ऑर्डर, इग्नोर डिफेक्ट इग्नोर करके नंबर चढ़ जाएगा, उसके बाद नोटिस करते हैं। एफए फाइलिंग नंबर 3028 of 2026. The learned counsel for the appellant is present. He submits that the office defect is to be ignored. The appeal has been filed against order of rejection of the counterclaim, and the learned court has held that the counterclaim itself is not maintained. It submits that the same amounts to a decree. Yes, further submitted that by the order of this court, we reported in 2006 SSC online date 492. The pending proceedings were clubbed together and were directed to be decided by the Court of Judicial Commissioner Ranchi. The improved order has been passed by the additional Judicial Commissioner Ranchi, who is of the same rank as that of the Judicial Commissioner, and the applicant does not have any other duty apart from reviewing this order. He has further referred to the judgment passed by Honorable Kolkata High Court reported in the IR 1991 Capital Petition. To submit that the rejection of harmful amounts to after hearing the counsel for the applicant, the office defect on the point of maintainability of this appeal is ignored for the present, subject to any objection that will be raised by the respondents. The party defect removed at this the legal counsel for the applicant has submitted that the remaining defects have been removed. Office to proceed, post this case and the applicant will put it on this list.
Orders item 11, first appeal 134 of 2024.
This was issued on respondent number 88 through concerned police station by order dated 6/2/2024. He has received it personally. Service is from
respondent?
8A. Respondent number 8.
8A.
Yes. He told not it.
AP number 154 of 2024. The learning counsel for the applicant has submitted that the respondent number 8 has received the notice from the concerned police station as per the service.
Regarding other respondent, so
With respect to other respondents, they have already been served. Respondent number 8, the substitution.
Yes, IA number 16597.
When did you get?
Respondent number 8 that one 22/9/2024.
The learning counsel for the applicant has submitted that IA number 16597 of 25 has been filed for substitution of respondent number 8, who died on 22/9/2024, and the petition seeking substitution has been filed by the affidavit dated 9/12/2025. There is a delay of 353 days in preparing the petition seeking substitution. A prayer has also been made for combination of delay and for setting aside abatement. It submits that by the order dated 11/6/25, the present prosecution was admitted and notices were directed to be issued, and service upon respondent number 8 could not be served. The notice could not be served upon respondent number 8 as she was not present. And subsequently, fresh steps were taken, and the petition appellant came to know of the death of respondent and filed the petition seeking substitution. The names of the leaders have been mentioned in paragraph 5 of the application. Applicable objection. The learned counsel for the reading respondents has no serious objection, so that is a prayer of substitution. After hearing the learned counsel for the parties and considering the evidence meeting ID number 16597 of 2025, and being satisfied with the cause shown for the delay in filing the petition seeking substitution is continued, the abatement is set aside, and the idea seeking substitution is allowed. The learned counsel for that is directed to delete the name of respondent number 8 from the first item and insert the name of the heirs and successors of respondent number 8 in ready in the post. Time bar भी है. Time bar भी है. अब limitation भी है.
In the first opinion,
No, no limitation. What is the stage? What should we do? The case has already been admitted.
Yes.
What is the matter about?
this is
What was the
basis
suit for?
declaration of right title and interest filed by the plaintiff respondent. The suit was
Sale was void.
and also for cancellation.
Why was it void?
It was made pleading the pendency of the suit. They have contested that we are the stranger to the suit property. Based on that legal around, we
You are the plaintiff or the defendant?
defendant.
Record आ गया इसका? Record है इसका? कब करना है? When you want to do it? कब करना है?
कोई डेट फिक्स कर दे
बता दीजिए आप जो आपका चॉइस डेट है. चॉइस डेट बताइए इसके पहले कि लोग और मरने लग जाएं.
कोई भी डेट कर दे
They also final week of July में any date you find.
Notes तो बनाना पड़ेगा ना?
Yes, जी.
The proceeding was ex parte or contest?
Contest.
How many witnesses were present? 11 witnesses for plaintiff and
7 witnesses in the
7 witnesses for defendants. Defendants file common statement.
apart from defendant number 2, the respondent number 8, it was ex parte arranged.
It was ex parte?
Ex parte. She was the purchaser. I sold my land, the sold property to her, but she didn't appear before. Defendant number 2.
Okay, and it was this same witness was on the challenge. So now, where is respondent number 8? Respondent number 8 A and B को अपील में नोटिस तो नहीं हुआ. अभी तो सब्स्टिट्यूशन हुआ है, ठीक है? तो 8 A and B को हम लोग अपील में नोटिस. The learned counsel for the appellant has submitted that respondent number 8 was the main contesting defendant. Correct?
We are the contestant.
Was the plaintiff?
She was the defendant. She was my purchaser.
Okay.
I sold
That's just a moment. The learned counsel submits that the respondent number 8 was the purchaser of the property from the co-defendant in the case, and the co-defendant is the appellant in this case.
Defendant number 2 sold the land to the defendant number 4, the respondent number 8.
Defendant number 2 sold the property to defendant number 4, who is the respondent number 8 in the present case and has been substituted by an order of this court today. Let notice be issued to the substituted legal heirs of respondent number 8, that is 8A and 8B, in the main appeal to the concerned police station, for which vacancies be filed within a period of 1 year. The counsel for the parties have submitted that they are otherwise ready for final disposal of the present case. आप एक हफ्ता में कर दीजिए. Post this case on 5th of August, awaiting service.
Item 12, first appeal 125 of 2026, along that on 13 and 14.
Appellant. First appeal. You are first CCA. Otherwise the case is covered. Otherwise the case is covered. Is there any other judgment passed in connection with the same proceedings?
Actually, but this judgment is appeal is valid of 8%. 48 is also possible.
The judgment has been passed against that person?
Yes, for the one of the respondent.
Who was that respondent?
Respondent number 5 in addition. Sabija.
Name, sir? When did she die?
(26) 2021. I filed a supplementary annexing the death certificate as well as the Aadhaar of the user.
You have filed supplementary?
Yes, sir. I filed supplementary annexing the death certificate as well as the Aadhaar. Annexure S by 1 was the death certificate.
Okay, date of death is 36/21. And the legal heirs, who are the legal heirs?
Only one surviving son is there, your leadership. The Aadhaar card of that son is annexed S by 2, on behalf of whom I have also filed a complaint.
S by 2. What is the name?
MD Mumtaz Ali.
So it's a nullity, we can't do anything about it.
Your leadership, on the last date, your leadership had raised this concern, but your leadership had also stated that if her rights and interests had been represented by the
Madam,
कोर्ट नंबर 11 मान लीजिए
the
son,
same family member.
काउंटर फाइल
son
के
is not the
उसमें
party
सिग्नेचर
here.
छोटा
Son was not the party in that.
Son is not a party in the proceedings. He is not a party.
That is true.
तो अब्बास अली के बच्चे तो पार्टी नहीं है, right? Her interest is not represented. How is Abbas Ali related to late Mahbub Hassan? How are they related?
जैसा मुझे बताया कि ये leadership that दादी या दादी लगती हैं कि as informed to me, and the son of the respondent number 5 had also come along with the other 4 respondents only, and he has also stated that I did not have any grounds, I was represented along with the family members. Therefore, that's the only ground.
Where are you? You have
The
to say
information
something.
is received from the respondents, that is all I can say.
That's the names.
I bow down, I bow down.
Land acquisition proceeding क्योंकि apportionment भी तो होगा ना, किसको कितना share मिलेगा.
Yes.
Not only the quantum but also apportionment. So they are having different interests. There is a conflict of interest also when it comes to
that.
Had her sons been on record, then the situation is different.
That is
Oh, the learned council's opinion on behalf of the parties. The learned council for the opinion presented that the impugn judgment is a nullity in the eyes of law. Inasmuch as impugn judgment जरा देखिए page 19 impugn judgment ये कौन सा वाला है? सबीजा खातून है ना?
ये केस नंबर
हाँ ठीक है.
अवार्ड नंबर 1.
Impugn judgment passed in LA case number 30 of 2005-6, being award number 124, is a nullity in the eyes of law inasmuch as
case number 169.
169.
Just one page. case is 169.
Okay, and LR case number is 169 of 2012 is a nullity in the eyes of law inasmuch as the one of the claimants may be Sabja Khatun, wife of Abbas Ali, was dead during the pendency of the proceedings. Her death certificate has been placed on record by the respondent, and her date of death is 30/6/2021. The learned counsel for the respondent has submitted that she had only one son, namely Muhammad Mumtaz Ali, whose Aadhaar has also been placed on record, and he has appeared by filing a wakalat. It is not in dispute that Sabja Khatun was not substituted before the court, and the judgment has been passed on 15/6/2023. The learned counsel for the applicant submits that the interim judgment and award with respect to the aforesaid case being LR case number 169 of 2012, LA case number 3 of 2005-6, award number 124 be set aside, and the matter can be, and it will be kept open to the applicant, to the parties to appear before the court, so that appropriate steps be taken for substitution and the court will proceed in accordance with that. After hearing the learned counsel for the parties and considering the fact that one of the claimants, namely Sabja Khatun, wife of Abbas Ali, died during the pendency of the proceedings before the learned court, and other co-defendants and the co-applicants / awardees were sons of Mehboob Hassan, and the only son of Sabja Khatun has also filed a wakalatnama before this court. This court is of the view that the interim judgment with respect to their proceed LR case number 169 of 2012 is a nullity. However, it is made clear that this order will not stand in the way of the parties, in way of the applicants.
They were required to substitute it.
You have to go to the court, and now you have all the legal heirs and successors.
They were on their behalf, the reference was made. They have to take steps.
It is made clear that this order will not stand in the way of the other claimants, other applicants / awardees, or even the son of Sabja Khatun to take appropriate steps before the learned court. And upon such steps being taken, the learned court shall pass fresh judgment and award in accordance with it. This appeal is according to discussion. अभी कंडोन नलिटी है तो क्या डिले कंडोन करेंगे? बाकी सब रिस्पॉन्डेंट्स की तरफ से कौन है? You are for the other respondents.
other cases.
No, इसमें दूसरों को नोटिस हुआ था?
हाँ सब 1 to 4 जो अलाइव थे उनके तरफ से भी हम ही अपीयर किए थे और 5th की तरफ से
Whose substitution are you seeking?
Substitution of respondent number 1.
This is arising out of LR case number? One 71. Who died?
Respondent number 1.
Bablu Manji.
As per the information.
When did he die?
After judgment.
After judgment.
Yes. 2011-20.
2011-20. There is a petition for substitution.
You find IE lawsuit. IE number 9156.
Notice हुआ है. Notice हुआ है.
Other respondents को notice. SR report के basis में
9156 नहीं 9211. कार्ड केस में लिखा गया है.
9211.
आईए नंबर 9211/26 अपना आईए नंबर चेक कर लीजिए. In FA number 128/26, the unit counsel for the appeal submits that the respondent number 1 died after the judgment. Died on 20/11/2024. The names of his legal heirs and successors have been mentioned in Para 7. एक क्या 7 और 8 दोनों की?
8 में 7 में दिया है years का नाम और 8 में पूरे सब्स्टिट्यूशन के बाद.
क्या है ये Para 7 क्या है? He left behind his wife and 2 sons. ये दिया.
एक में party position को.
And Dashmi Derby has also expired. The legal heirs have been mentioned in paragraph 8 of the application. The notice be issued to the proposed legal heirs and successors of.
I have already filed the wakafnama.
He 7 and 8 में explain करिए क्या लिखे हैं? What have you written? Dashmi Devi has also expired. Yes. One A, 1B, ये दोनों चीज क्या लिखे हैं? भीष्म मांझी and अनिल कुमार. ये भीष्म की जगह भीष्म छप गया है. क्या है? भीष्म की भीष्म.
भीष्म.
इसको ठीक करिए ना. तो पैरा 7 ही ले लेते हैं. The name and name of legal heirs and successors have been mentioned in paragraph 7 of the 823 application. Let notice be issued to the proposed legal heirs and successors of respondent number 1. The details have been mentioned in paragraph 7 of the 823 application to the concerned police station for which it is filed within a period of 1 week from today.
I already filed wakafnama, Your Lord.
On behalf of?
All the
three?
Yes.
तो कोई सब्स्टिट्यूशन में तो आपको कोई प्रॉब्लम नहीं है.
नहीं, कॉस्ट में भी कुछ 5000 अदर टैग मैटर में कॉस्ट
सब्स्टिट्यूशन में लिमिटेशन है. The Mr. So and so has already entered a clearance on behalf of the proposed legal heirs and successors of respondent. After hearing the learning counsel of the parties and considering the fact that respondent number 5 has died after the filing of the judgment and being satisfied with the prayer for substitution, the ID number 9211 of 26 is read out. The counsel for the applicant is directed to delete the name of the respondent number 1 from the first item and insert the names of his legal heirs and successors in their name during the course of the day. कोई delay भी है? Delay का लोन करते हैं. Awaitment satisfied कर. Yes. What else?
One more.
तो अब इसका क्या करना है? Record आ गया. There is a limitation also. कहाँ है limitation? 2313.
2313.
Rest of the respondents have appeared.
Yes, sir.
You have appeared. State के अलावा भी तो होंगे ना?
I am representing all the respondents.
You are representing all the respondents.
Yes.
बताइए delay कितना है?
147. No, 160.
116. 116. IA number 2310 of 2026. This petition has been filed into combination and delay of 116 days in filing the first appeal. The learned counsel for the applicant has referred to the evidence made in the integrity application. The learned counsel for the private respondents has no serious objection so far as condemnation or delay is concerned, but he submits that some cost will be imposed. After hearing the learned counsel for the parties and considering the fact that the present case is a first appeal, the delay in filing the appeal is hereby concluded, subject to payment of cost of rupees 5,000 to be remitted by the applicant in the bank account of one of the respondents, whose details be forwarded by the learned counsel by the respondents to the learned counsel by the applicant within a period of 1 year. Okay? Record आ गया इसका?
Yes. 21 को final disposal में other tax matter please.
21st?
Yes.
21st को आ जाएंगे? तो फाइनल डिस्पोजल के लिए
Other tax matter.
कोई बात नहीं, लेकिन उस दिन एडजर्नमेंट नहीं होगा, उस दिन जितना है मैटर आप ऐसे करें, ठीक है? उसके बाद ये केस फॉलो करेगा. Holds this case on 5th of August. The receipt regarding the payment of cost be filed prior to the next. इसका क्या है? Substitution. Respondent number 2 has expired. Okay. आपने वकालत नामा फाइल कर दिया?
Yes.
IA number 9155. The learned counsel for the applicant submits that the respondent number 2 has expired on 28/2024 after the judgment passed by the court. The names of legal heirs and successors have been mentioned in paragraph 7. He submits that the applicant came to know about the death when the respondents were died when the appeal were listed on 17/6/2026. The learned counsel for the proposed legal heirs and successors of his parliament have already made appearance. He has no serious objection so far as prayer or substitution is concerned after hearing the learned counsel for the parties and considering the government's reading IA number 9155 of 2026. The prayer for substitution is allowed after sitting aside after convening the delay and sitting aside the counsel of the applicant is directed to delete the name of the family from the hostage and insert the name of the legal heirs and successors in their name during the process. So, argumentation. IA number
312.
IA number 2312 of 26 has been filed seeking condemnation of delay of 210 days. The learned counsel for the respondents has opposed a prayer for condemnation of delay. However, he submits that in case this court is inclined to condemn the delay, it's a cost we imposed after hearing the learned counsel for the parties and considering the fact that the present proceedings are first appeal arising out of 9 litigation cases. the delay in filing the appeal is hereby condoned subject to payment of cost of rupees 5,000 to the respondents. The cost be remitted in the bank account of one of the respondents, whose details be forwarded by the learned counsel for the respondents to the counsel for the argument within a period of 1 week. Post this case on 5th of August, and the receipt regarding deposit of cost be furnished before this court prior to the next day. दूसरा भी 5th August को ही है. ये फाइनल डिस्पोजल में रख दें दोनों मैटर्स को. हाँ, चलिए इसको दोनों को फाइनल डिस्पोजल में दोनों को है ना 5th August को दोनों.
Item 15, first appeal 239 of 2026.
There is an IA for additional evidence. वही सेम आई एम सप्लीमेंट्री के थ्रू ओरिजिनल कॉपी और सर्टिफाइड कॉपी, ओरिजिनल कॉपी ऑफ द सेम डीड एंड सर्टिफाइड कॉपी ऑफ द पार्टीशन सूट आई हैव प्लेस्ड इट.
Which is that IA?
IA number 847 annual 2026. I am going to file a counter till date in lordship.
क्या बताइए till date what?
Stay क्योंकि they have
Stay
already
कैसे आप लोग तो खाली ऐसे सोते रहते हैं जब मन होता है तब ये
they have already withdrawn their share of amount. अब जो बचा है वो that we are claiming that our share उसमें तब तक वो stay नहीं है.
ऐसे कोई डिस्कस कौन करता है?
फिर
आप इंटरेस्टेड हैं नहीं इंटरेस्टेड?
नहीं.
डिजिटल एविडेंस नहीं है. Eight 479 is the idea. उसका supplementary file.
Yes, 13/7/26.
You should actually see the reasoning given by them in the RTA, putting additional evidence at this stage.
You file your reply to the IDA. You will hear it along with the first appeal, right? And when you want to do the first appeal, yes.
Currently, 1 week to file, at least 1 week to file.
Okay. 1 week to file the reply to IDA. That will be sufficient.
Maybe get like after the 3rd week of this week, after 24th,
After 24th August?
No, this month. I'm saying this month, not the next month. This month.
The letter counsel for the parties are present. ID number 8479 of 26 has been filed for additional evidence. A supplementary affidavit has also been filed on 13/7/2026. The letter counsel for the respondents wait for 2 weeks' time to file a response to the interrogatory application. Praise for and is granted 2 weeks' time to file a response to the interrogatory application. We submit that the interrogatory application seeking additional evidence be heard along with the filing. Considering the assumptions, the interrogatory application seeking to reduce additional evidence and read with the supplementary affidavit will be taken up along with the final hearing of the supplement. The reply, if any, to the interrogatory application as indicated above be filed in 2 weeks. Rest of the respondents have appeared.
Yes, sir.
The learned counsel for the parties have submitted that 14 is insufficient redress
This Mr. Manish will start taking down by order date to worship. See.
I do not know object continue. Yes, speed post are 12, received item 13, item delivered 14 is insufficient address.
Kindly see order dated 8 June 2026.
I am a very important.
For 14 you are appealing. The councils have submitted that, otherwise the case is ready for final disposal. क्या matter है?
Land application.
Apportionment of share.
Yes, yes.
कितना लड़े हैं आपको? You belong to the same family.
We are claiming through a sale deal and the partition suit that happened in 1986.
Partition suit also.
That-
Sale deed executed by
One of the
co-sharers.
And also the partition suit against the defendants who were the ancestors of the. I humbly.
They are party in the proceedings.
Their ancestors were ex parte.
That's
Till date watch Spain. थोड़ा सा
आइए कहाँ पाई?
आइए है 5567 of 26.
67 of
आइए नंबर 5567 of 26.
they have taken their share.
They have
It is-
taken their share.
It is your share which is kept.
They have already withdrawn whatever the share they had. Now the rest of the amounts have.
कभी stay order किए हैं पहले?
Before we appear to worship this tomorrow.
That's right. हम सब order किए थे, हमको याद है कोई stay
Yes.
order हम किए थे.
Kindly see order dated 6/5/2026. It was extended by order dated 8/6.
Post this case for final disposal कब करना होता है या
End of this month.
2 हफ्ता तो आपको reply फाइल करने के लिए चाहिए.
Any date will be next month.
On 6th of August 26, at this the Learned Council for Document has submitted that the interim order dated 6/5/26, which was extended on
8/6.
by order dated 8/6/26 will continue. Considering the submissions, the interim order dated 6/5/26 extended by order dated 8/6/2026 is directed to continue till 6th of August. Final disposal, record आ गया?
Yes.
Record आ गया? The councils for the parties are directed to submit a synopsis of the case and the judgments which is secured prior to the next hearing. Synopsis रहेगा तभी केस हो पाएगा, ऐसे नहीं होगा. नहीं फाइल करिएगा तो स्टे एक्सटेंड भी नहीं होगा. वेकेट कर दीजिए. दोनों चीज नहीं चलेगा ना, स्टे भी होगा और टाइम भी नहीं लगेगा.
Permission item 24, criminal revision 1074 of 2017.
Yes.
So this revision.
Why this revision is before?
Justice. Order was passed by the Honorable Mr. Justice E.Q. Srivastava. That's right.
The period order was.
Now it is assigned.
Yes, assignment.
क्या करना है? Admit नहीं हुआ अभी तक.
Bail, you have custody period हो गया लॉर्डशिप.
इसके bail हो.
6 months का
सजा कितना है? कौन सी सेक्शन में से?
279 original order trial court order recording of 6 months rigorous imprisonment under 279 and 304 for 2 years. However, in period order lordship, that order was modified to the extent of 304 section 304A and the imprisonment period was reduced for a period of 6 months in the period order. Not during the pendency of this revision or the petitioner has already undergone half the period of.
तो आपका बेल ऑलरेडी हो चुका है ना, यू आर ऑलरेडी ऑन बेल, तब क्या करना है बताइए, रिकॉर्ड आ गया है। ऑर्डर शीट रिकॉर्ड ऐसा तो है, क्या चाहिए बहस करिए।
Petitioners, Lordship, approx 81 years of age, Lordship. And such, there was been on medical grounds that since he had already undergone a period of half the period of leadership, this particularly modified to that. In a similar manner, leadership had passed another in the was modified.
इसका इंटायर रिकॉर्ड्स आया हुआ है, बाकी सारा रिकॉर्ड्स। आप रिवीजन ऐसे बहस करेंगे वैसा ही आप आधा लाइन का ऑर्डर करेंगे।
On point of leadership from the expert
पूरा मेंस का सुन के ही ऑर्डर होता है, ऐसा नहीं है भले ही यू आर कंफाइनिंग योरसेल्फ ऑन द पॉइंट। व्हाट इज द which section में कंडीशन यू आर अल्टीमेटली 279
337 304
337 304A।
Yes.
कितने लोग मरे हैं?
One child or 6 years.
Son of the
हम तो फाइन करते हैं, बहुत लंबा चौड़ा तैयार। बहुत केस फाइन करेंगे, फाइन जमा करेंगे इसमें 50,000 रुपये का डायरेक्शन था। में मिनिमम सेंटेंस किसी में है?
मिनिमम किसी में
मिनिमम नहीं है। 304A में मैक्सिमम कितना? 3 साल। 2 years। Are you sure? लाइफ है 3 साल से तो कम नहीं होना चाहिए। Years. That's date of incident कब था?
1st of November 2008.
1st November। कोई आपका एंटीसीडेंट है? आपकी उम्र 81 years।
Date of incident 62 approximately 63 years.
फिर रिकॉर्ड आप नहीं देखेंगे, आज इसको फॉर्मली एडमिट करके फाइनल डिस्पोजल में नेक्स्ट वीक लगा देते हैं। एंड आई एम जस्ट रिकॉर्डिंग दैट यू आर कंफाइनिंग योरसेल्फ टू द पॉइंट ऑफ सेंटेंस। उस दिन कर थोड़ा सा देखना जरूरी है। और the learning council secretary on behalf of the parties, the learning council for the petitioner has submitted that the petition has been convicted for offence under section 279/337/304 capital A of IPC, and one child 6 years old has expired in the relaxed. He submits that the first appellate court has reduced the sentence. However, he has further submitted that he shall confine his arguments on the point of sentence. The petitioner has already remained in custody for a period of 6 months.
6 months custody period, 3 months
for a period of 3 months, and the petitioner is 81 years of age as of now. The learning council has relied upon the order passed by the school, including revision number 109 of 2019, decided on 4/4/2024, and they submitted that in the present case also, similar order will be passed. The learning council for the state is present. His admission also examined. The records have already been received from the consent board. This revision is already included. Post this case for final disposal on the 10th of this in number of seconds. The next week. Job is that we expect to be taken up at 2:15 or after the bill matters. Good. The bill matters come later. Otherwise, it will be taken up.
Item 25, WPC 1480 of 2019.
Was it at the last order, there was a direction to file supplementary evidence. Was it by play or one each time?
An extra one translated from that Arthuric subject.
Yes, you have not filed it. ये आधुनिक विषय का जिसने
This is a lordship which I have inquired by my client. They are also a teacher. They say a trained certificate must be obtained by the teacher in subject particular. That is आधुनिक. Any subject.
नहीं आधुनिक.
What
आधुनिक in English translation is not subject.
It's a subject.
आधुनिक विषय.
आधुनिक.
बताइए कब तक फाइल करेंगे?
They lost 2 weeks time.
Madam is appearing for whom?
Jack, they have recommended my case that I am entitled for one.
You have recommended
Yes.
that they are entitled.
For not the petitioner, they have made recommendation that madrasa is fulfilling all the criteria.
So that not for fun.
That has to be released by the state government. We are just implementing.
Otherwise, you don't have any objection so far as entitlement of the petitioner.
We can't comment on that. I can't comment on that. That petitioner is entitled on.
As per the last order, lordship.
Madrasa has fulfilled all the criteria, the building part and all. So we have
Building part, but so far as
building
the
part
staff is concerned.
Inquiry has been made, your lordship. And decision has to be taken. We are just the recommending, but the decision has to be taken by the state.
You see, you have to make your recommendation not only on the building part but also on the staffing pattern. So what is your stand so far as the staffing pattern is concerned? Because there is an objection with regard to trained teachers. So according to you, they satisfy all the conditions?
Your lordship, that is not clear with the.
So you should make it clear. You should also file your application.
Yes.
WPC number
As per annexure 2160, they have not recommended. They have made an inquiry for the teacher. They have annexed the list which I have annexed at page 119. Their inquiry at page 116, which contained the list of teacher also, that Jack. And they say that we have made an inquiry and given this inquiry it took for further action by the director education.
WPC number 1480 of 2019, or the Learning Council's opinion on behalf of the party, the Learning Council for the state. Pays for how much time do you need? Pays for 2 weeks time to comply the order dated 3/7/2026. The Learning Council for the JAC is also present. She also is directed to seek instructions as to whether, with respect to the order dated 3/7/2026, and file a clear affidavit as to whether the petitioner satisfies the madrasa involved in this case satisfies the required condition. Then it could be done within 2 weeks from today. Close this case on 7th August. The affidavit is to be filed by 3rd of August.
Item 26 contains civil one.
Yes,
On
it
that
can
we
be.
can.
On 14th, the affidavit should be filed by 7th.
Yes.
Order has not been complied with.
That the outset.
What are you doing?
Item
Because my
26.
request for 215, Lord, the SBI is to assist in this matter, Lord, we not in court right now, but we requested for 215.
They will take care of the first matter.
Why are you not complying? इसमें क्या ego है आप लोग को?
If I
Extend
raise
करते जा रहे हैं and you are not doing the needful.
215 will be taken up with his real assistant.
We'll fix कौन किसको ऊपर हम लोग को responsibility fix करनी है?
Leadership has left them handed over a supplementary show-cause. In which now leadership, they have come up with an entirely new way to circumvent your leadership's order. Now they are saying leadership, we have devised a new way to recognize the service associations, and because that way is not yet been implemented, we have not been able to recognize them. And leadership, what is worth
See,
noting?
the point is that they had a recognition till a particular period. That period has now expired. We held that the de-recognition cannot extend that. Now you recognize them, and whatever you are doing to others, do the same thing to them also. If the recognition is being extended to others, it should be extended to them also.
I would have this. It's just that there's a request from the side of the holidays yet to be taken up at 215.
Let us see. But tell him my peace of mind,
Yes, Ms. I will.
because this is being unfair. Or we will draw a contempt suit.
We should post leadership's orders on 1st of May. They have on 25th May. They have come up now with a new policy of
They will go
recognizing.
on doing that.
Yes,
But so far as their recognition is concerned, they cannot be treated as unrecognized.
Whatever has to come from the solution to that. Like,
Item 27. Contention Bill 1119 of 2025.
Last order, they have released it, the recent order, and they have recalled their order and passed an order in favor of this petitioner.
So you are not happy.
To the extent that they have, HRD has done their part, so far approval is concerned, now the role comes of the university, so now it is their duty to make consequential payments. Last date,
So
Mr.
that will be done. That will be done. The record is
I
undertaken.
have been paying that they will come, because he's a retired person in 2022, it will make hardly any difference. 2 weeks time we will give him the meantime.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that now the needful has been done by the state. The matter is pending before the university. Or calculation and release of payment.
Raj University has also notified the petition. Now we need to calculate the area amount and make payment. So we require 4 weeks time for making
The
payment.
learned counsel for the university says that the matter be posted after 4 weeks, and in the meantime, admissible amount will be remitted in the account of the petitioner, so that the entire case becomes meaningless. Was this case on 20? चौदह तारीख को 14 अगस्त आपसे आजादी चाहिए
हम उस दिन अच्छा लगेगा
आप आजादी इनको दिलाइए चलिए The need will be done by 13th.
Yes. Item 28. Content Bill 36 of 2026.
The learned counsel for the parties are present.
I have some justification. We can see the order.
It's not there. She's yet to file this application.
No, the order.
Passed by
the
this
contempt,
court.
yes.
What is it that is still troubling you?
Leadership only page number 13, paragraph number 3 we can use. There was a submission that plot number L91 is to be given. There is no question of alternative plot that is to be given. That was the grievance, and this court has also observed in paragraph number 5, after hearing the learned counsel for parties and considering the nature of the grievance, court finds that the respondent housing board has submitted that they will take appropriate steps for evicting plot number L91 from the enclosures and hand it over.
L91 is not being
So L91 has not been given. They have taken a decision that alternative plot. Now they have taken a decision that alternative plot L89 will be given. I am satisfied to that extent. However, an allotment letter must be given to me, and I should be handed over the physical possession because that was the main grievance. That order may kindly be given.
Has been given?
The show cause that they have recently
They say that physical possession has
let
been
the
given.
show cause be kindly be handled.
Let us see.
Annexure B related to NDC page number 10. In that it is written that he has been present, it has been demarcated and all of that, but however an official order or letter must be communicated to the petitioner, including the allotment letter, because if in absence of any allotment letter, this
They have given the allotment letter at annexure A.
annexure A is
L89.
to Om Prakash Oraon, it has not been, it says उपर्युक्त विषयगत प्रसंगित पद के संबंध में कहना है कि स्वयं स्थित भूखंड L91 की श्री रविंद्रनाथ तिवारी द्वारा इकरारनामा निष्पादन की सारी प्रक्रिया कार्यालय द्वारा पूरा कर लिया गया है एवं अतिक्रमण के कारण स्थल पर दखल कब्जा नहीं हो पाया। बोर्ड के सुसंगत नियमावली के तहत वैकल्पिक आवंटित भूखंड एवं L89 पर दखल कब्जा देने का निर्देश प्राप्त हुआ है, अतः उक्त संपदा का विधिवत दखल कब्जा देकर यथाशीघ्र अधिकार
फिजिकल पोजीशन आपको मिल गया है लेकिन अलॉटमेंट लेटर नहीं,
which is important unity, so क्योंकि कोई और प्लॉट का ऑर्डर था
The learned counsel for the parties are present. The learned counsel for the petitioner submits that as per the order passed by this court, the respondent housing board was to hand over plot number L-91, but on account of certain reasons, the same could not be handed over, and plot number L-89 is sought to be handed over. He submits that the supplementary show cause which has been filed today reveals that physical possession of the plot number L89 has been given, but so far no allotment letter has been issued to the petitioner, without which the mere physical possession is of no consequence. The learned counsel for the housing board is directed to seek instructions and annex a copy of the formal allotment letter, which might have been issued to the petitioner or which may be issued to the petitioner. How much time do you need? Post this case on 31st. Let the supplementary show cause be filed by 29th. There is a allotment letter के बिना तो you will be nowhere, as a physical possession is of no consequence. Housing board का बहुत काम है, supplementary show cause के लिए. Supplementary show cause has been filed during court proceedings.
Okay. Item 29, content civil 224 of 2026.
आपको तो रिप्लाई फाइल करना
Yes,
है।
reply.
क्या रिप्लाई?
My lord,
खतियान गलत?
no, my lord has directed to file the Khatiyam. And they have filed the Khatiyam, and it is well admitted that this is Garmajar work. Kindly have you looked to para 4 of the impugn order below. The main issue is related that they have not produced the cell deed, my lord, correct cell deed. And so the respondent state has said that it is only for the reason that they have not produced the correct cell deed, and so the payment has not been made. And here the direction of this honorable court to produce the original cell deed, and the same has been produced. Now they are.
It is arising out of a land acquisition proceeding.
Yes.
So why didn't you file a land acquisition case?
Land acquisition case because they have not given the rightly status of the land. Kindly see the annexure 6 of the petition. That is the basic issue. The court of additional collector has passed the order in favor of the petitioner below.
If the land is Gair Majulba land,
Yes.
how will you get the royalty status over this?
Yes, madam, it has been acquired in 2006, madam. And there is no such provision. Payment has been given to
to other Rayat Milo. They have to file the present status of the Khata number 147, which is Garmajagua land, where they have given compensation to other Rayat. But because it has been directed to file only Khatiyan, they have filed the Khatiyan. I have an expert kindly see
this cannot be resolved.
Here only the CO is the contender. Here met CO party, not the district land acquisition officer. And
See, we
there is
cannot
specific
really resolve this issue anymore. In a content proceedings, we cannot do it. It is a Gair Majura land. If you still have any device, you go and file your suit.
the land has been.
You go and get your title declared, and then you.
It has been declared below.
In which suit? In a suit?
Which suit? The land when the.
Who has declared your title?
I have mentioned in Paramilo.
Who has declared your title?
It has been decreed in court, my lord. Thereafter, the petitioner has purchased the land.
By virtue of a decree?
Yes, my lord. I have mentioned.
Decree was against whom? The state?
No.
Then?
It has been decreed in between the parties.
That's right. That is not binding on the state.
Then
Then
how the state can take the title of the land, my lord, without any proceedings?
See, that it is a Gair Majura land. They want to take it. They have taken it. It is their land.
No, from which provision they have taken this land, my lord, or from when? Because kindly see the annex, my lord. I have annexed, my lord. Page 11, my lord. Still, the petitioner
It's
is
a government land according to them. They claim that it's a government land.
Since when it became the government land, my lord?
Government land, it was always government land.
No. See, by which provision? Because kindly see page 11, my lord. Still, the petitioner's name is running in website, my lord, as a Rayat, my lord.
वेबसाइट से तो सब नहीं चलेगा ना?
उसमें वो लिखते हैं कि 74 डिसमिल जमीन इनका है, जबकि मेरा 80 डिसमिल है, इन्होंने 22 डिसमिल एक्वायर किया है, तो 74 डिसमिल ये कैसे शो कर रहे हैं? That is the
difficulty. The council's opinion on behalf of the parties. The learned council for the state has submitted that the Khatiyan has been filed, which shows that the property involved in this case is Gair Majura land. Meaning thereby it belongs to the government. The learned council for the petitioner has submitted that there was a title suit amongst the family members of the petitioner, and this property was partition suit, and the property was partitioned, and other co-sharers have been granted the compensation, but no compensation has been paid to the petitioner.
Was there other persons who had their Majorva land which has been expired?
Other persons who had Gair Majorva land which was acquired have been granted compensation, but petitioner has not been granted such compensation. After hearing the learned council for the parties on considering the fact that there appears to be land dispute and no relief can be granted to the petitioner in this proceedings. Accordingly, this court is not inclined to proceed any further in this contempt proceedings, which is hereby brought. However, it will still be open to the petitioner to take steps as may be permissible under law to claim compensation.
Lord has because purchased land, Lord, so there must be a permit about this schedule.
The learned council has submitted that the property was purchased by the petitioner by virtue of a registered sale.
Item 30, CLP 259 of 2026.
CLP has been filed for small modification in the judgment passed by the motion. In para 82 of the judgment, at page 49 version.
Yes.
Page 49, paragraph 82 version. The bold part, the last line says that in favor of Nagesh Chandra Agarwal subsequently transferred the property in favor of father of this whole contesting defendant. It was actually transferred in favor of the defendant lordship and not in favor of father.
In that respect, I have annexed the written statement also and the salary note.
How does that make a difference?
Later proceedings in subsequent stages, it might make some problem.
It's absolutely unnecessary.
Matter of record but salary also suggests that it was transferred in the name of present petitioner, not in the name of his father.
You have not filed SLP, you have lost the
It
case.
has been confirmed by the Supreme Court also.
Then,
But the part of the report is correct.
it has been confirmed by Supreme Court. Where is that SLP on?
That has not been annexed. That was
Why have you
confirmed
not
at the
annexed?
subsequent stage after filing of the CMP.
Where is that order?
I have not attached it to this petition.
Essay number 136 of 2022, particularly essay number 136 of 2022. This is absolutely unnecessary. Which sale date? Which is that sale date?
That is at page number 81.
No, it must be mentioned in my judgment.
Yes, sir.
Which is that sale date?
CMP of year 1987.
Which is absolutely unnecessary. इसका कोई मतलब नहीं है. ये executed by Hari Shankar and others by deed number 6147 of 1986 at Calcutta, right?
Yes, sir.
तो ये तो है इसमें लिखा हुआ.
This has been reported that it has been transferred in favor of father of the contesting defendant, but it was actually transferred in favor of the defendant itself, not in the name of his father.